We see courtroom drama on TV, but the real action often happens before trial, when a case gets dismissed. What if prosecutors legally had to give the defense evidence that proves innocence? Failing to do so can get a case thrown out. And if police collect evidence by breaking the law themselves, like an illegal search, that evidence can be declared unusable. Even a confession becomes worthless if a suspect wasn't properly informed of their right to remain silent. These aren't loopholes, they are strategies. We will break down the key tactics lawyers use to dismantle a prosecution's case. Before a lawyer even looks at the evidence, they ask a fundamental question. Should this case have even started? Every arrest must be based on probable cause, a reasonable belief a specific person committed a specific crime. It's more than a hunch. It requires concrete facts. If a lawyer can show the arresting officer lacked sufficient facts, the arrest is deemed unlawful, and the entire case can crumble from the very beginning. The Constitution guarantees a speedy trial. If prosecutors take an unreasonably long time to bring a case, a defense attorney can have it dismissed for that delay. There's also a time limit on the crime itself. For most offenses, the government has a limited number of years to file charges. If they miss the deadline, the case is invalid. But what happens when the initial arrest is solid and the case is on time? The answer for the defense attorney lies in the evidence itself. The defense doesn't have to prove innocence. The prosecution must prove guilt beyond a reasonable doubt. This high standard is a defense lawyer's primary target. A crime has elements. Theft requires taking and intent. If a lawyer shows just one element is unproven, the case fails. A case might hang on one person's testimony. A defense lawyer will search for bias or past lies to argue the witness is simply not credible. Prosecutors use expert witnesses, but a defense can challenge credentials or methods, showing their science isn't so certain. So you can attack what the evidence says, but what if the evidence seems strong? The next line of attack is to challenge the process. Remember the illegal search. This is the exclusionary rule. Any evidence found from that illegal action is fruit of the poisonous tree and gets excluded from trial. Let's return to a prosecutor hiding evidence. This is a Brady violation. Prosecutors have a constitutional duty to turn over all exculpatory evidence. If a lawyer finds that evidence was withheld, like a witness who saw someone else, it's a violation of due process. This can get a case dismissed permanently. Sometimes the fatal flaw is much simpler. The formal charging document must be precise. A wrong name or date can be grounds for dismissal. Sometimes the defense admits the act occurred, but argues it wasn't a crime. This is entrapment. When police induce someone to commit a crime, they never would have. So it becomes clear, it's not always about who did it. It's about whether the state followed the rules. What other rules can be used? Beyond constitutional rights and clear misconduct, cases can fall apart due to simple human factors and logistical failures. What if the one piece of evidence that could prove innocence, like a DNA sample, is lost or destroyed by the police? This can lead to a dismissal. A court needs jurisdiction. If a crime happened out of state, the court can't hear it. No jurisdiction is a direct path to dismissal. A prosecution's case can rely on one person. If they recant, refuse to testify, or disappear, the case against the defendant collapses. And then there is the most direct attack, a factual defense. A strong alibi, backed by receipts or GPS data, directly attacks the prosecution's entire narrative. Now, let's connect the dots. A weak probable cause for a stop can lead to an illegal search. The evidence found is then excluded. One failure creates a cascade. A defense lawyer's job is to audit every government step. They test the foundation, the rules of engagement, and the final product. A failure at any stage can be fatal. The reality is, most cases don't end with a dramatic court dismissal. When a lawyer exposes these weaknesses, the prosecutor often agrees to drop the charges. So, what does this all mean for our idea of justice? Is the system broken, or is it working exactly as it was designed to? Our legal system is adversarial. It's designed for two sides to challenge each other, believing this process protects the innocent and checks state power. The strategies we've discussed are the tools defense attorneys use to enforce those rules, holding the prosecution and police accountable to the highest standards. So, cases are dismissed not because of loopholes, but because a lawyer showed that the state failed to meet its burden of proof or broke its own procedural rules. Understanding these strategies reveals that a vigorous defense is not about obstructing justice. It's a component of it. For anyone facing the system, this knowledge is power.